Hello, Mark Chatterton of Charterhouse Chambers. I want to speak to you briefly today about the consequences of making a mistake within the portal. And there's a recent case Mahoney versus the Royal Mail, which was decided on the 26th of May 2020 by a deputy district judge in the Truro County Court. And the background to the case was that there were, at stage 2 of the portal, the claimant made an initial offer of £5,750. That was met by a defendant's offer of £4,000. The claimant intended to submit a revised, reduced offer of £5,550, but actually typed in and submitted an offer of £550. Well, obviously, the defendant was aware that that was a typo, but immediately accepted the offer and promptly made a payment by backs. Well, at that stage, the claimant realised that they had made a mistake, and so they attempted to negotiate their way out of it. They returned the money, but to no avail. The claimant therefore issued Part 7 proceedings, and these were struck out back in May as being an abusive process. And the Deputy District Judge held that the common law doctrine of mistake, does not apply within the portal process, and that it doesn't matter that everybody knew that a mistake had been made. The portal is in fact completely binding. And the deputy apparently gave the example that if everybody knew that a claim was worth, say, £25,000, but within the portal process it was said to be £25, then the parties would be bound by that. The magnitude of the mistake is an irrelevance. Gosh, well, you might think that this is absolutely outrageous. It can't be good law. This is only a deputy in a county court that's a very long way from anywhere. Well, it may well be outrageous, but unfortunately it is good law. There have been at least 2 previous examples of less extreme cases than the one down in Truro, but cases that have been similarly decided. The first one, a case called Draper against Newport in 2014, was decided by District Judge Baker in the Birkenhead County Court, and subsequently similar finding was made by His Honour Judge Parker in the Liverpool County Court, a case called Fitton and Aegeus in 2018. Those of you wanting to read a bit more about the Fitton case can perhaps unsurprisingly find it on the DWF website. Well, what lesson are we to take from this? If it goes wrong, there's no point complaining because you can't do anything about it. Injustice is neither here nor there. You are bound by the figures within the portal process, within stage 2 of the portal process. So when you submit your own figures within the portal process, check, check, and check again, and perhaps have a supervisory check before they go out. On the other hand, if you are potentially the beneficiary of a mistake made by the other side, then Don't be tempted to do the decent thing. Don't be tempted to get on the phone. Just take the money.